Okay, it's 3:45. Hello, everybody. Welcome to the DLCV conference. My name is Brian McMahon. I'm a professor at VCU. I'm pleased to have been invited. I want to thank Nicole and Celicia, my friend, and Nicole, our organizer. Our moderator, and Sim, our organizer. Nicole is pictured up here on the main screen with me. She's moderating today. She'll be working the chat room, kind of monitoring any comments or questions you have that we will raise. Perhaps not all of them, because we may run out of time, but when we get to the discussion period. Appreciate it if you'd allow me to finish my prepared remarks, and we'll have 10 or 15 minutes or so for discussion before the 4:30 hour arrives. The topic here is taking a deeper dive into ADA. I've interpreted this to mean how has the how has the ADA behaved? If you can think of a law or a policy as being something that has behavior, you'll see that, yes, laws do change and behave in different ways. I'm a psychologist by training and a rehab counselor and a case manager. And I've been studying this matter since, believe it or not, about, well, actually 1978. I went into a business in public access well before the ADA. But active in writing and publishing what was happening with ADA beginning in about 1987. Law was passed in 1990. The law became effective, depending upon the title of the law, in 1992, roughly. In some cases, there was a variance in that by about 6 months. The ADA can be summed up in 3 sentences. The first 2 sentences apply to Title I. Most of you know about the major titles of the ADA because, after all, you signed up to take a deeper dive, so I'm going to assume you have some experience or knowledge of the spirit and intent of the law. If you don't, that's fine too, because these 3 sentences will give you enough of a foundation for our purposes today. And the first is in Title I, which relates to employment and what the protections are for people with disabilities in employment. My interpretation is, my best definition is, all personnel actions must be unrelated to the existence or consequence of disability. Okay. Now, some personnel actions place you more at risk than others. For example, the personnel action of you getting fired is much more consequential than if you got a smaller raise than you'd hope for, right? But all personnel actions, everything between the pages of a book, of the personnel policies and procedures of the agency, which could be small like this, it could be very large like this, everything between my hands would be a personnel activity or policy, must be unrelated to the existence or consequence of your disability. A second sentence is, when it comes to that, everything in that book is subject to accommodation if that accommodation is reasonable, which means it's not a significant difficulty or expense upon the employer or the business. That's Title I. Titles II, III, and IV are all about public access, all about creating a flat earth, an accessible environment in the United States for people with disabilities, to entitle them to access to all the goods and services of citizenship in places of public accommodation and private accommodation, in government services and transportation and communication and so on and so forth. All aspects of public life, not what you do in your home. Some areas are exempt. It's not a law about housing. It's not a law about air travel, for example. There are other laws that pertain to that in terms of providing access. But in all the areas where there were big gaps, all people are entitled in the United States to access, to get to participate in the goods and services of citizenship. One of the best ways, particularly in private sector, when we say, well, what is a place of public accommodation? basically means a place where money changes hands, or services are bartered or change hands, or the services are your right because of voting or driver's license and so on. So you see, it's very, very sweeping law. Certainly the most ambitious law since the Civil Rights Act of 1964, and in many ways modeled after the Civil Rights Law, but also modeled after the 1973 Rehabilitation Act, Titles 501, 2, 3, 4, and 5, which had the underpinnings of what the ADA would become, and allowed us a period from 1973 to 1990 to experiment, to do things different in different communities and states. Maybe everybody wasn't obligated by these laws, but federal employees may or may not be, state employees, people who receive federal funds were obligated by these laws, and people who received money from the government, not just federal contractors, but public institutions. For example, if you were processing federal student loans in a university like at VCU, where I'm standing today, you would find yourself getting some ADA literacy long before there ever was an ADA. But ADA just formalized all of that. Now, I direct this project, which I'm going to share with you today. It's called the National EEOC ADA Research Project. It is a public project. It views workplace discrimination as a virus. We take a public health view. That's not a public project, but it's intended to say a public health view of discrimination. We see it as very insidious. We see it as very un-American. And this slide is 10 years old. The project goes all the way back to 2003. And I'm telling you, you're about to, I think, really learn some information about how the ADA is played out that very few people have had any exposure to whatsoever. But we see it as a really evil thing in our society to have discrimination against people with disabilities. It's very un-American. And because there's a resurgence in that with things like Black Lives Matter and the return in interest, which I'm so excited about in terms of social justice. This is indeed a social justice presentation. And the ADA, of course, is a major, major civil rights document. If you want to read, for example, a great case study in what ADA can accomplish, you might want to study a class action case documented by Dan Barry, who wrote a book on it. The book is called Boys in the Bunkhouse. And it'll show you the incredibly evil practices that we're engaged in with African-American males with intellectual disabilities on a large scale in a class action lawsuit dating back to as recent as 2013. We're going to make a great movie out of this book one of these days. So you might want to pick up a copy and read it sometime. So what do I have in this EEOC ADA research project? The EEOC, of course, is the enforcement agency for ADA, just in Title I in the employment provisions. For now, we'll just talk about the employment provisions. But I have all the closed cases, every allegation, if you can imagine, that's ever been brought to the EEOC by any American citizen, alleging, meaning very important, we study allegations. Allegations that they've been discriminated against at work. From 1992, when the ADA became effective, to 2016, I have every single one of those if the case has been closed. And there's 823,568 of those. More than, it's about 83% of 1 million cases. So you can tell a lot of stories, and I can tell stories about who the charging parties were. These are the people with this disability who filed the allegation. I know about their impairment, their age, their gender, their ethnicity. I can tell you where it happened in the purple. I can tell you in the purple slide portion on the right about the employer, how many workers they have, for example. In some cases, they're industrial codes. Down on the bottom in the orange, you see issues. So issues is, if you say you have a dispute with your employer, something's at issue. So what's the issue? What is it you're fussing about? Well, these are the personnel actions. There are 24, 25 distinct personnel actions. You can read those in the little slide boxes. They have to do with getting a job on the left, keeping a job on the right, or working conditions. So we're going to talk about those, but it's pretty easy for you to see that what is it you're fussing over? Are you fussing over you've been unlawfully terminated? Are you fussing over wages? Are you fussing over whether or not the doctor was entitled to require a medical examination from you at a certain point in time in employment? Are you fussing about being laid off? What is it you're saying happened to me with an adverse consequence because of the existence or consequence of my impairment? And the box on the blue is very, very important because it tells us in the end, more or less, who won the dispute. This is the resolution of the case. The EEOC investigates these cases. They have several hundred investigators from coast to coast in every state. They're right across the street here in Richmond. We have a very big, active EEOC presence and office in this wonderful federal courthouse. And then their investigation in the end favor the person with a disability that we call the charging party, or does it favor the respondent, which we call the employer? If it failed if it favored the charging party, then we say that case has merit. In other words, it wasn't just an allegation. It wasn't just an allegation, it's just a perception of your disability. But really, after an investigation, it probably took 6 months to a year in duration. The EEOC concurs that your allegation was verified, that an actual discriminatory event occurred. There was reasonable cause to believe that, and your case had merit. So of course, if you're the disabled person, you'd feel pretty good about that. On the other hand, if you were the employer and there was no cause, no reasonable, the misbehavior of the employer did not rise to the level of discrimination, and there was no reasonable evidence that it occurred or it occurred the way the charging party alleged, or if it was closed on a technicality. So if there was no cause for discrimination to say that discrimination occurred, or closed on a technicality, that's what we call in NEARP a non-merit closure. In other words, if the case is closed today and the two parties meet and one wins and one loses, who goes home and is sad and who goes out and has a beer to celebrate? That's kind of merit versus non-merit. A non-merit closure favors the business or the employer. This is a true research collaborative. How busy are we? We have published 90, over 90, close to 95 now, publications that are in print already. We do about 5 every year. We've been going since 2003. I don't do these things by myself. I've directed this until just this past year. Started it in 1993. There were over 95 scholars around the country from over 20 universities. About 20 of these people are from VCU, but the rest, the other 70, are from many, many universities engaged in disability studies. Some are law professors, some are disability policy people. Over 10 dissertations have been completed, about 5 of those at VCU. Over $4 million dedicated in a research grant and support to VCU from 2006 to 2011 to support our work. Over $4 million, that is. And today the project is in the trusted hands of the University of Kentucky, along with the EEOC and the University of Chicago, which really coordinates the whole matter now through the National Organization of National Opinion Research Center at the University of Chicago. So they're in very good company. I still keep my hand involved, of course, because I enjoy database mining and writing and publishing articles of this nature. And articles of what nature specifically? Well, I think you can see when you've got a data set like that, you can start writing stories about the characteristics of charging parties, for instance, on the basis of their gender or race or age, or most often we do it on the basis of their specific type of impairment. So my first two studies were, for example, were one, selfish me. I was type 2 diabetic, so I studied diabetes. My second study was selfish me again for my son, who was epileptic, and I did the second study on epilepsy. So people come to us and say, the biggest requester of us is the MS Society, and we've done 10 publications for them. And they pay us to do those studies because sometimes they can become expensive. They're very specific questions they want to answer. So the type of impairment, the type of employer, big employers, small employers, employers in different types of industries, different parts of the country. Another thing we can do is we can predict the outcomes of cases. So if we have people watching today from the EEOC, or certainly from the Disability Law Center here in Virginia, you might be surprised that if you had a client that filed a complaint tomorrow, and you could give me about 10 pieces of information about the situation, I could predict what the EEOC outcome will be, merit or no merit, with about 95% accuracy, with a 3-point margin of error either way. That's pretty good prediction, but that's with a database like this, that's the kind of artificial intelligence that you can apply to a case. So when a person says, well, if I'm going to go through this process for a year, what would be the chances of winning? I could actually answer that question for them, and they can decide whether or not it's worth going forward, or they want to put their energies into finding another job, a better job, just letting this issue pass. That's totally up to the individual, of course. And we do impact studies. How did the Supreme Court decisions called the Sutton Trilogy affect the ADA? Did they damage it? Did they reduce the protections for you as a disabled American? And indeed they did. They weakened the law dramatically. And the number of allegations and complaints dropped, and the merits rate dropped. This happened from around 1997 through 2002, and it was a really terrible situation because the tremendous protections that are provided to you in Title I under ADA were really, really sacrificed and damaged. I don't want to go into all the aspects. I'll go into a few of the aspects. Suffice it to say, we did studies also on the ADA amendments came around to reverse all the Sutton Supreme Court decisions. And not only did they do that, but they did more. So when the amendments came out, not only did they restore the integrity of the initial act, but they made it even more modern and more, providing better protections. In other words, there were certain things that the businesses got out of the amendments and certain things that people with disabilities got out of the amendments. But believe me, in 9 out of the 10 disputes that occurred, disability people won 8 to 9 of the 10. So it was a real strong message that Congress is not fooling around when they passed this law almost unanimously the first time and almost unanimously the second time in both houses of Congress. Really, where does a civil rights law come about in recent times that you've heard about that all of both houses of Congress in resounding numbers will pass these things on a voice vote? This is a great and a very strong law, and it's here to stay. Other things happened, like the 2007 to 12 Great Recession, which had a terrible impact. The adverse consequences as reported by the Department of Labor in the Great Recession were, if you were a non-disabled American, they were amount X. If you were a disabled American, the negative impact was 1.5X. So they were 50% more severe to people with disabilities. And we can document that stuff with these studies. Finally, the trends in ADA. So ADA is 30 years old now. So certainly it changed because disabilities changed, things like HIV. There's far more labor force participation today and people with HIV and far fewer employment complaints than there were in the mid 80s when it was such a big scare. All kinds of emerging disabilities, rare disorders, the influence of labor unions, what the alternative definitions of disability, like not only are you protected if you're disabled in real time today, but you're protected if you were disabled many years ago, or if you're not disabled at all and the bosses think you are and behave towards you as though you are, or if you have a close associate, you are a close associate of a person with a disability and you've been punished for that because maybe you supported them in their EEOC claim or litigation matter, all those people are protected as well. So it's that we're going to throw those prongs out. The alternative prongs in the definition of the original definition of disability. Business wanted them out. It was this research that I'm telling you about that saved the prongs, because we found the prongs had more legs in terms of growing actual filing of claims and more merit when the claims were filed than even the claims related to I'm disabled today in real time. Pretty amazing. And that's what research can do. And that's what we mean here kind of by a deeper, a deep dive. What I'm showing you here is not the shallow water, but we're putting a couple of feet in. But if you want to read the 90 publications, you'll see how deep it goes and how much there is that can be learned. Look, for example, here are six major findings that emerged from our work. First, employers would say the scope of ADA discrimination is a tsunami of litigation. The fact is, it's very modest for all titles 1, 2, 3, and 4. Business talks about a tsunami of litigation that is yet to develop. If you are a business so big that you have 1,000 workers, and congratulations, because only 2% of employers are that big. And you are an employer that big, the odds that you would get a single allegation, a single complaint in any given year are about 1 in 5,000. Is that a tropical storm of litigation? And the public access, it's even lower in terms of filed lawsuits in federal court. We'll illustrate those in a moment. Point number 2. There's 24 issues in terms of the personnel actions we showed you. I used to do training on all 24, 25. It took me a day and a half to do that. Now I just do training on 5, because these 5, firing people, the failure to reasonably accommodate, problems with the terms and conditions of employment, disability harassment and intimidation, and hiring, those 5 account for 76% of all the discrimination under ADA Title I. I'm not saying the other, 19 are not important, but they're very, very tiny. And they are in that order. Workplace discrimination is about keeping your job. 5%, and if you said hiring and related, maybe you go to maybe 8% of all complaints are about anything that's hiring related. Yet, when we do ADA training, we talk about hiring. Who knew? That's not where the lion's share of workplace discrimination is. Lesson number 3, in event, if you are an employer, for business people out there, if you get a complaint, stay the course, let the system work. Work with the EEOC, answer their questions. And this is the sad truth, my friends, in the disability community. You win one out of 5 cases. Excuse me, 1 out of 4 cases. Your merit rate is 24% of all closures. The employer prevails 76% of the time. And before you get too angry about that, and you say, how is the law working then? Try to understand those ratios are about the same for the civil rights protected classes of gender, race, national origin, state laws and sexual orientation. I'm not saying these are impossible cases to win, but they are difficult. And it also shows that maybe there's some frivolous litigation, or maybe people with disabilities don't fully understand their rights and responsibilities under the Act. Next line is merit rates are very high. If you want to predict merit, you learn things like this. Merit rates are very high in hiring issue for males with physical or sensory impairments. They're very low for merit rates in firing, except for AODA impairments. Who would think that people who use drugs and alcohol win in an EEOC judgment more often than other disabilities? But those are some of the facts. Here's a funny finding, and it's very creepy. It's about disability harassment and intimidation. You already know the definition because it's the same as it is in gender, except the word disability is substituted for sex or gender. Disability harassment and intimidation, as we all know, are very insidious phenomena. Let me ask you a question. What three impairment groups do you think experience the most actual disability harassment and intimidation? By actual, I mean claims that had merit. It wasn't somebody's false belief. They're things that really happened and were proven. Who has the highest merit rates when it comes to the harassing and disability harassment and intimidation of disabled Americans? And the answer is these three impairments: intellectual disability, brain injury, and deafness. And you can bet when we found this out, I was hopping mad. Because who would think that what do these disabilities have in common? Problems in communication and problems perhaps at least even temporarily or for a period of time or maybe on a lifetime basis of totally comprehending what's happening around you, that you're being harassed, that you're being intimidated, and why. So you have cognitive issues or sensory issues that make it difficult for you to understand. How much more insidious can disability harassment get in a situation like that? Here's a magic slide. Don't worry, you don't have to worry about this too much. I looked at right to work states versus union security states. So red states versus blue states. There's roughly 25 of each. Which group, union or non-union, has more disability discrimination? And to get right down to it, because time is short, I can answer it this way. Adjusted for population and the size of the workforce in the state, you group all the states, you put it all together, you do a little simple math called odds ratios, and you find out that for every 100 allegations in a union state, there are 160 allegations in a right to work state. End of story. What we do about this, I don't know. I've never even published these statistics, but I'll get to it and redo and update the study one of these days. What about the public access provisions, though? What are the lessons there? Tsunami of litigation. Here you go. Last complete year, 2019, there were 11,000 lawsuits filed. Okay, in a workforce, I'm going to use the smallest number. There are about 8 million businesses, but 5 million of the businesses have like one employee. In other words, I have a company, Ashland Youth Focus. The employee is me, so I don't have employees. So you take away the lone wolves, and you got about 3,500,000 employers. So what that means is your odds last year of getting a suit against you because you didn't remove the barriers in your environment, in your business, are less than 3 in 1,000. Yes, 3,000ths up, no, 3,000ths of 1%. It's less than 3 in 100,000. And of those 11,000 in 2019, 2,256 were now about website accessibility and lawsuits in the federal courts. On public access, there's a lot of, there's some litigation. By the way, a lawsuit ends up going all the way to court about 4% of the time. Otherwise, it's dismissed in summary judgment, or a settlement occurs, or somebody or the charging party basically gives up on it. This we learned from the Job Accommodations Network, how accommodations are changing over time. I just thought you'd find it very interesting that the first thing they learned is that the ADA Amendments Act is working beautifully. The focus of the business no longer is to be on whether or not you technically meet the definition of a disability. It says person will get the benefit of doubt. There's a much broader definition of it now. And that is what employers had been using to keep people from going further in their charge, in their complaint. That is done in the investigation that Congress has directed the courts to please direct your business to, did discrimination occur or not? Were accommodations provided or not? And get off of this, who's disabled and who's not. Okay. In the future, by the way, they also said since the ADA accommodations are new, there's much more on emphasis today on work leaves, absence from work or leaves as an accommodation, service animals in the workplace, modified schedules of work. So the new issues happening in accommodations had never happened before, but one issue you can always count on that there's still tons of complaints about is parking. That's like, seems to be fixed. Written in cement, I'd hasten to say, if I didn't think it was such a bad example. So the other thing we want to think about a little bit is, is a merit could be bad or good. It can be bad because it's very sad that an actual and verified discrimination event occurred, because it's unlawful, insidious, and a cause of substantial distress. But merit can be good as well, because it shows that when we're filing complaints, we want a high merit rate, because we want to see the ADA literacy rate of disabled people in America come up, of the charging parties. We want more charging parties, but we want them to understand their rights and responsibilities and bring forth strong case and strong evidence. So high merit is very high for sensory impairment and hearing impairment, more than all other disabilities. And then that turns the coin on other issues. For example, if you're really into the cross-disability movement, and all the disabilities need to organize and work together into one big massive association so they can really make change, how do you explain that? Disability does seem to make it, the impairment seems to make a difference. But the point is, State VR, for example, has separate divisions for deaf people and blind people. And when you look at it, they're discriminated against in very different ways, and they get very high merit. And so maybe there's justification for that. whereas the cross-disability people would say that's terrible. We need to all be organized as a single whole. So strong utilization by specific disability communities in that their advocacy efforts are working is evidenced in the cases of higher merit. So we have 10 minutes left. It's exactly what I hope we'd end on. This is just a taste of the kind of work we do at NEARC. You can download any of the research I've mentioned, those 90 publications at my ResearchGate site, and holler back at me through email at vcu.edu. It's btmcmaho@vcu.edu, and I'll be glad to respond to any questions you have. I'm happy to take questions or comments from the group now, and I'm very interested in what you think and what you have to say. We have 9 minutes left.
Yeah, so if anybody has any questions or comments, you can enter it in the chat. We don't have the ability, I don't think, to unmute people, but if you type it out, we can make sure it gets answered. And right now, I'm not seeing any questions.
Any thoughts or comments?
One person just commented just saying, please wait. We have a question from Rhonda Thyssen asking, can you explain the prongs you mentioned earlier?
Okay, so to be a disabled American and get protections under ADA, you have to have a disability. A disability is defined as a significant impairment that causes a functional limitation in one or more life areas. Okay, that's pretty simple. That's called the prong. It's not a prong at all. That's the generic definition. The prongs are 3 variations of that. In each case, you have to meet the first prong. You have to be talking about the first prong. A significant medical impairment usually used to be can be described by a physician, but that causes you a significant limitation in one or more life areas. Only have to have one life area. Now, prong 2 says, let's say, you had cancer and for 6 or 8 years, your life was a disaster, but you're in remission. You've been without cancer for 8 years, 7 years, 5 years, whatever is the window of kind of safety, and maybe this is really all over. Well, believe me, prior to ADA, people were discriminated against because of their history of cancer. So if you have a history of a significant impairment that significantly limits one or more life areas, you're also protected by ADA. You don't have to be ill or disabled in real time today. That's the first alternate prong. The second one is really arose a lot out of HIV. A person has HIV. They're seen at a person does not have HIV. We're in the midst of the HIV hysteria period of the early 90s, all through that decade, just rampant hysteria about it. And, I can't say without good reason, nobody knew everything about transmission, and was it toilet seats, or was it just intravenous drug users, or was it certain sexual practices? But somebody shows up at the Christmas party with his boyfriend, and the boyfriend doesn't look too well. So the first person goes, you know, to work back the next day after the holidays and is terminated. You see, but he's perfectly healthy. So they trump up some reason about his performance or some such things. A lot of this was discussed in the famous movie about HIV. And how can you fire me? What are you firing me for? You fire me because I'm gay? No, we're not firing you because we're firing you for performance. But the point is, it was his relationship with somebody who was ill or presumed to be ill that led this person to be fired. So those things happen too. Other cases are mothers of children who get very sick. I went to a cancer hospital once. I said, what am I doing to talk to a bunch of mothers about childhood cancer when they're not? And I said, how many of you have had job problems since your kid got cancer? And 40% of the hands went up in an audience of about 100. Well, they're not sick. Why are they getting laid off and terminated? Because the employer wants to save health costs, or the mother's going to miss a whole lot of work now. The point is, that's unlawful too. That's the second problem. And the third is because of your known association with a person with disability, and that really gets to the heart of claims about retaliation. So you understand, if a person gets unlawfully discharged, for example, and you were a coworker and you supported them in their claim with the EEOC, doesn't have to be that serious, but because of your relationship and your friendship with that person, you got whacked too. That's unlawful. So you don't have to be yourself disabled in two of the prongs, or yes, you had to be disabled by history, but you're not disabled today. That's the third prong. All those things were salvaged in the amendments because of the work we did on this project. I can tell you that firsthand. And the amendments were a big victory to restore it. And it shows the importance of, you want to stop a virus or you want to stop a fire, you've got to study the virus. You've got to study fires, and you've got to let the science dictate what happens. Even in a social justice mode like this, science and research always becomes important. It can't just be done on legal cases alone. I've lost track of time. Are we out of time?
We have a couple more minutes, and there's another question. Anne is asking, what are the rate of other claims, specifically autism?
Okay, I'd have to look that up in the code book for you. There is a categorical group for autism, and we've done some studies on it, but I'd have to look that up in the code book because there are 45 impairment groups, and I didn't bring that with me today. So if you have a special interest and you want a little mini profile or a couple sentences about what's the status of this disability or that disability, please just email me and I'll be happy to respond to that.
Okay. We have just a couple more minutes. Are there any other questions?
I know I've got a pack of students in that group sitting out here watching this, and we have class in a half hour. So I'm glad I'm down at the university because I'm not going to bother going home to prepare now. I'll just stay here and wait for you all to show up. Thanks so much for your time and attention. Thank you, Nicole. Thanks to Sim and Celicia again, and all the people at the host agency, the Disability Law Center of Virginia. I'd like to work more closely with you in the future if you're interested in this kind of work. I suspect you are. And I hope this was meaningful to all of those who were able to attend today. Thank you so much for your time and attention, and stay in touch.
And thank you for presenting.